A psych evaluation stalls a 17-year-old girl's murder trial until the summer in Georgia. And a Connecticut teen acquitted of murder last year in a fatal house party stabbing may now again stand trial for manslaughter this time. And in a billionaire filmmaker case, he's famous for his Medea movies. He's being slapped with another lawsuit that also names an even bigger Hollywood entity. It's the court of law, where it's all about the law and the facts. But let's turn the page and call to order Court of Opinion. Welcome to Court of Opinion. I'm Julia Janae. Thank you for being with us this hour for something a little different here on Court TV. It's a space to air out the opinions and the sometimes controversial viewpoints on the biggest trials and most talked about cases, all based on the most pivotal facts. And we've got a brilliant panel of experts on deck for you. Whether it's the court's final opinion or the court of public opinion, we are digging into all of it right now. This hour, we are beginning in Georgia, where a trial was set to begin today in the case of a 17-year-old girl accused of killing her mother and stepfather in their home. But all of that came to a halt this morning. Before we dive into the details on that one, here's Court TV anchor Ted Rowlands to get you caught up on the case against Sarah Grace Patrick.
When James and Kristin Brock were shot and killed in their bed in the middle of the night last February, everybody in their rural Georgia community was shocked. Kristin's then 16-year-old daughter, who called 911 after her 5-year-old half-sister found the bodies, took to TikTok to express her grief, even reaching out to podcasters to raise awareness of the unsolved murder.
She messaged me back on June 3rd and just said, search up Brock case. So I said, Brock Turner? Brock who? She said, Kristin and James Brock. They're my parents. And out of nowhere, a random Thursday night in February, someone came in my house with me and my 5-year-old sister, and my parents left them for me and my little sister to wake up to.
To some, Sarah Grace appeared to be the grieving daughter trying to solve this senseless crime. But to others, including some members of her stepdad's family, her tearful eulogy didn't feel sincere.
I just wanted to say goodbye to my mama and James since we never got the chance to. I was so used to you guys always being here to the point that I never once thought to imagine y'all not being here.
5 months after the violent deaths of Kristin and James Brock, Sarah Grace Patrick, accompanied by her father, turned herself in on charges of murder and aggravated assault.
Mountains of evidence has gotten us through here today. Lots of processing, lots of working with our law enforcement partners to get us to where we are today that honed in on her as a suspect.
Sarah Grace is charged as an adult with malice and felony murder and aggravated assault. She could face life in prison without parole if convicted of murder.
Here at Court TV, we were gearing up for jury selection, which was expected to begin today in Patrick's trial. However, the trial was delayed after prosecutors said they needed more time to review a preliminary report on a neuropsychological evaluation that was conducted by an expert for the defense.
Based on what's been presented for me today, I will place this on, I believe it's August 3rd. We'll place this on August 3rd. And with the understanding that if I'm going to bypass 2 trial weeks in order to get there, I'm bypassing the 2 days that I can set it on, right? But by doing that, I'm giving defense and state all the time that you could possibly need to have this case ready. And August 3rd needs to be our day. We need to come in August 3rd, ready to pick a jury. All right? Where everyone's on the same page.
Yes, sir.
You heard it there from His Honor. 8 months out is when we are going to see this trial go forward. And as for Patrick's family, they're divided. Some family members during a hearing in August described their fear of the defendant.
Your Honor, it feels like I'm living in a nightmare. I'm depressed. I struggle to sleep. I can't even walk through my own living room without seeing his urn and be reminded of everything all over again. I miss my father deeply. I wish I could see him again. I wish he could have met his grandson. And above all, I wish I could just hear his voice one more time. But instead now, what I have is an urn that represents memories we made and the countless memories that will never be. I believe the defendant poses a serious flight risk. Her family has significant financial resources and a wide support network, both of which could easily be used to help her evade law enforcement if she were released. These are not speculative concerns. They are grounded in the reality of her background and the means available to her. Additionally, based on her past behavior and what I know of her personally, I do not believe she has the integrity or accountability required to face the consequences of her actions. She has shown a willingness to avoid responsibility, and in my opinion, she would absolutely attempt to flee rather than stand trial if given the opportunity. In addition to the risk of flight, I am deeply concerned for the safety of my family. The gruesome and violent details of this case have shown me that the defendant has a disturbing lack of regard for human life. If someone is capable of what happened here, then I cannot ignore the real possibility that she could pose a threat to those of us left behind.
But this is not an open and shut case. Remember, I said they are divided. Patrick has strong community support from her church and even from her grandfather, Dennis Nolan, whose daughter, Kristin Brock, is one of the victims in this case. And he told Court TV he believes in his granddaughter's innocence and thinks that investigators were, quote, desperate to arrest someone.
She was here, and whenever we shot guns, they were rifles. I never saw her shoot a pistol, but I just can't imagine you know, the accuracy that that gun had in her hands. It just, I don't think it could happen.
Now, again, jury selection in the Sarah Grace Patrick trial now scheduled to begin on August 3rd. The judge granting the state's continuance request, making it clear, though, to both sides that they have to be ready for trial on that date. And she could face life in prison without parole if convicted of murder. She's being tried as an adult. Let's get right to our power panel. Our guests with us, starting with here in studio, we have trial attorney and partner at Kessler Law Firm, Dwight Williams is here. Joining us remotely, we have criminal defense attorney and former prosecutor and former CIA officer Jack Rice and criminal defense attorney Eklund Mercy here. Great to see you all. Happy New Year. Thank you for beginning the year with us. Dwight, I want to start with you. Tell me your opinion of this case in Georgia where you practice.
Yes, it's gotten quite a bit of news in our neck of the woods, and you know, once again, it's one of these cases. What else could have occurred here beyond this child found these victims? The teenage daughter was there. It seems as if she is the prime suspect. Obviously, she's awaiting trial. Now you've got this curveball with this psychological evaluation. Not quite sure why on the eve of the trial that is all taking place. It must be very frustrating for the victims. At the end of the day, I feel like the state's got a pretty strong case, or at least they seem to be banging their chest saying that they've got a pretty strong case against this 17-year-old. It'll be interesting to see what this psychological evaluation reveals. But I'm thinking that, you know, certainly it's unfortunate it had to happen right on the eve of the trial when everyone's kind of ready to see the wheels of justice start moving.
Oh yeah, 11th hour. And to your point, this curveball, this was actually an evaluation done in August, and they did not have a response or final report on it until recently, and the defense doesn't even have the final report. So Eklund Mercy, let me get to you. What do you think may be in that report that has the state saying we want a continuance? Why wouldn't they have already gotten an evaluation of this defendant?
Well, I think, unfortunately, evaluations like that, they do take time. And once you have new evidence, you can't risk it. With cases like this, especially with a victim like this, you just can't take a chance, and you don't want to take a chance on this type of case if you're prosecution, because we have sympathy because she's young, and also the psychological factor is real. With social media and how she approached her parents' death, how she approached it with the church, how she kind of just loves the publicity of it all. You can see that her aim was infamy. And with that being said, as a prosecutor, you need all of the information. So with that report, you want to be able to understand what was said, understand what the capabilities are, understand, potentially protect from cross-examination. There's a lot of things, and that new evidence you can't sniff at. You gotta examine. So I think that the continuance was warranted.
Okay, you mentioned her actions right after the death of her mom and her stepdad. Let's take a listen back to her eulogy in a video that was posted to Kristen Dowda's Facebook. This is before she was arrested.
I just wanted to say goodbye to my mama and Jamie since we never got the chance to. I was so used to you guys always being here to the point that I never once thought to imagine y'all not being here. I didn't have a single clue how much I needed y'all until now. Although there's nothing we can do to bring them back, we still have control over how we treat people with us today. I love you guys, and so do I. And so do they. I'm sorry.
Jack Rice, you're joining us remotely. This psychological report could help explain some of that for the defense, because this is a young woman who walked away from the crime scene treated as a victim. She wasn't arrested for many months. She was given assistance, consoling. She was taken in by friends and family. What do you think about where we stand right now in this case?
Come on, Julia. They knew this psych eval was coming. I mean, remember, the defense can certainly ask for it. The prosecutors can ask for it. The judge can do it sua sponte. They can do it themselves. So that's not a surprise. And frankly, at least if I'm in this space and I'm representing this person, the first thing that I'm doing is the psych eval may be a piece of this as strategy. Sometimes it's because I see incompetency and then I feel compelled. I have an actual ethical obligation to do this. And frankly, I would then disclose it to everybody in the room generally, not just because I want to know what she's like. I want to know actually what's coming. And there are sometimes this stuff takes a long time. And I think the prosecutors knew this was coming. That's one of the reasons they came back and asked, because they would be yelling at the judge 3 months ago saying, what's going on? We know there's a psych eval sitting out there. We know that this is coming. And if this is just a delay tactic, let's nail it down right now so the judge is ready and mad at the defense when we sit in this space right here today.
Yeah, everyone said they were ready to go at the last hearing. And Dwight, the community support factor here, a grandfather who says she's innocent, church members who say we talk to her on the phone every day from jail. How does that impact how this case proceeds and ultimately gets decided?
Well, it's huge. I think it's huge in the, once again, the court of opinion, court of public opinion, in terms of, that jury pool and, what they're viewing, what they're seeing. They're not in a vacuum. They are watching things, hearing things. I think it's important for the defense to show that she has this family support, that they're in the courtroom behind her every day to back her up. I'm just curious about the motive here. I just haven't really heard much about motive or why this took place beyond this psychological evaluation. Are they angling for some sort of mental incompetency or reason of insanity defense? I just haven't heard much about that yet. I'm curious to see where that goes.
I thought we were going to learn a lot more in the opening statements. Eklund Mercy, last thoughts before we have to go to break. This case is one where the defendant has been tried as an adult. What are your thoughts on whether this should have been in juvenile court? This is murder, but this psych report may reveal a lot more for us.
Yeah, I absolutely think that based on the severity of the crime, that she should be charged as an adult. The only reason why is because it's murder. And in Georgia, those are one of the offenses that you got to be charged as an adult. However, I think that the social media aspect and the fact that there's no real studies, like research on young women, adolescents with crimes of murder, a lot of the research goes to young men and a lot of it goes to older men, but we rarely see research and just things that may be in that report is rarely discussed on young women. So it's going to be very interesting to see how the prosecutor is going to use this. I think that the prosecutor had a good eye in the sense that this could have been considered Brady evidence, and in trying to just protect everything and protect judicial judicial economy, I think that the prosecution did a good job of requesting the continuance. But remember, murder is those things that we don't have a statute of limitations. She can be charged and tried for murder, at any given time. It's best to have the best case that you can put forward.
And now they have 8 months to get their case ready for trial. Our power panel is going to stand by. We have to get to a break. When we come back, though, we're turning our attention to the case of an Ohio man who admits to the killing of his girlfriend. He was sentenced today, but we're asking, did his disposing of her body create an impossible case for prosecutors? We'll take a look at the best evidence presented in court today, including what the defendant's brother witnessed before the death of Amanda Dean.
Tonight on Closing Arguments, the latest in the biggest cases from across the country. We're live bringing you expert insight into all of today's new developments.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
The school shooting that broke hearts around the country and broke trust with law enforcement. Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage this week on Court TV.
I cannot begin to describe the magnitude of what you took away when you killed my daughter. You took her away from all of us. 4 sons must live without their mother.
No one will be able to see her ever again, and he acts like it's fine. Even right now, he's just looking down. He's acting like he could care less.
Her death was not an accident. It wasn't an illness. It wasn't a freak accident. It was cold-blooded murder. A pure monster did this. Others need to be protected from this inhumane monster. Amanda did not deserve this.
Amanda Dean's family there pouring out their heart in front of a judge this morning. This was during a sentencing for a man who now admits through his guilty plea that he was involved in killing his girlfriend, dismembering her, and disposing of her body. But what's perhaps more shocking is how that disposal likely led to a lighter sentence for Frederick Rear, the family of his victim. You see him there trying to keep her memory alive inside of that courtroom. Her body was never found. And we've heard the street phrase, no body, no case. But we've seen it time and time again here on Court TV. Situations where prosecutors, even without a body, successfully get convictions of first-degree murder. That was not the situation in Ohio today. A judge handed down a 9-year sentence for involuntary manslaughter, which was part of a plea agreement. Rear also received 1 to 2 years each for abuse of corpse and tampering with evidence charges, and that gave him ultimately a total of 14 years for the 40-year-old defendant. And the judge made it clear on the record that he couldn't hand down the maximum because there was no cause and manner of death proven because there's no body that's been found. Even though there was no trial in this case because of that plea deal, at today's sentencing, prosecutors presented evidence that could have come out at trial. But could it have been enough to go after Rear for murder charges? You heard her relatives saying this was cold-blooded murder. Our guests are going to weigh in as we go over today's best evidence. Up first, this is what our Court of Opinion team chose as number 1. Fred's brother witnessed the abuse. That's according to the prosecution. Body camera footage was shown in court today of the presumed crime scene. Fred Rear's brother seen on body camera being questioned by police about an incident that happened in a camper. The brother put his own hands around his neck when he was asked by police what happened to the victim, Amanda, inside of that camper. Take a listen.
Was Amanda ever back here?
Yeah.
She was?
Yep.
Where at? In the camper?
Yep.
What happened in the camper?
That's what happened in the camper? Yeah, put his hand around his neck when asked what happened in the camper.
Who did that?
He did that. He then signed, turned to his mother, made a hand, made motions with his hand as if he was signing something to his mother, and his mother said, "What Freddie do?" So that's the video recorded statement of Paul Rear insinuating or stating that he believed Amanda Dean was strangled and that the defendant strangled her.
Let's bring in our power panel. Here are our guests tonight. Dwight Williams, Jack Rice, and Eklund Mercy still with us. Eklund, I'm going to start with you on this one. I see you reacting to what we're showing you as the best evidence. What's your opinion about this case and the outcome?
How? I would love to. Prosecutors giving that type of... Remember, in order for the plea to take place, like the prosecutor has to agree to it. And if you're going to agree to that, to taking that type of plea, then you need to have something for it. Just thoughts and prayers is not enough. How are you going to offer him involuntary man, right? And then try to put it on the judge to give him the max. The problem is that we have a lot of prosecutors who are so focused on their conviction rating, and instead of what the families need. Try the case. Yes, you may lose, but at least the families get closure. This is the problem. It just seems really murky, and it's not fair. It's not fair to anybody involved. The fact is that they offered the plea with nothing from the defense. It's boggling my mind.
Jack Rice, you're a former prosecutor. Weigh in. What's your opinion on why prosecutors made this deal and didn't go for murder charges when we see it a lot here on Court TV? The Brian Walsh case is the one that's the most recent.
Yeah, you and I have talked about this. Circumstantial evidence works, and we have seen it work. Frankly, the prosecutors were weak in this case. They screwed this one up. You don't blame the judge. The judge gave 14 years in this case, and the max could have been 18 years. And the only reason that happened was because the prosecutors left the murder cases, the murder charges on the floor. The only thing he went down on was the involuntary manslaughter. And that's not the judge's fault. That's up to the prosecutors. Frankly, try the case. If you're arguing and you charged it out, and hell, even during sentencing, the prosecutors were trying to argue some of the evidence that they dropped and said, this is why he was guilty of murder. And the judge said, you're trying to get me to sentence him like he's a murderer when you yourselves were the ones who actually negotiated the plea for an involuntary manslaughter. It is their fault. It's not the defense's fault. They took advantage of it. It's not the judge's fault because he's stuck with what the prosecutors ultimately agreed to.
Dwight, I want to get your opinion in just a moment on whether you agree or disagree, but let's bring in what our Court of Opinion team brought in at number 2 for the best evidence that the prosecution had. And this is that Amanda voiced her fears of the defendant to her friends before her disappearance. One of her friends, Melanie, said Amanda texted her, "I know you'll come look for me if I go missing. If I go missing, look at Fred." Melanie said that Amanda feared Fred. He threatened bodily harm at her, and he threatened to kill her more than once. Dwight, what do you think about the evidence we've shown so far? Is that enough for this prosecution to have tried a murder case?
I certainly think that they should have gone for it. I'm flabbergasted that they did not make that move. You've got the families of this victim in the courtroom holding her image up. They deserve better in this case. I don't understand why this prosecutor took this route. This evidence, this best evidence, should have been the best evidence at trial, not at a sentencing hearing where you're now trying to convince a judge to do something that he is somewhat powerless to do based upon some of the statutory language. So it would have been better, I think personally, and I agree with all the panelists, put this thing up for trial. Let's have this heard. Let's have this victim's family have their day, really their true day in court to hear the evidence, hear the testimony, and let a jury of 12 come to a resolution. It's very sad that didn't happen here.
Eklund, do you think that that particular evidence of her voicing her fears to friends would have come in at trial? You know, great defense attorneys like yourself would have tried a lot to keep that out and say it's not a confession, it's an out-of-court statement.
Yeah, and we would have tried, but here's the thing, we would have had to try. In Fulton County, this would have been tried a long time ago. I don't understand. And the idea that, hey, they didn't have enough, we've seen it often. We've seen it often. I really think that the prosecution did a disservice in this case, and trying to paint it like they had no idea what was going to, you know, they had no control over it is really sad. It's really sad.
Jack, I want to get to number 3 and get your thoughts. This one's a unique one, and we don't know for sure that this would have been able to come in a court of law. But it's potential jailhouse confessions by Rear. After he was arrested and put behind bars, a police sergeant said that he overheard Rear say to his lawyers that there was no body because he disposed of it. There's also an inmate that shared a pod with him, Zach Boynes, who said he wanted to move out of that cell because the defendant kept talking about and screaming about murdering people and how he dismembered and disposed of bodies, and even told an investigator it's a lot harder to chop up bodies than you think. This stuff is unreal, Jack. React to that. What's your opinion on whether that could have come in, and should that be a reason to go to trial?
Well, if you're getting statements that are heard, now the question is whether or not they should have been heard, whether or not there was eavesdropping, whether or not that was appropriate. I mean, that's going to be the fight. But frankly, we never got there. We never got there because all of this information, this is sort of one more shovel of information that goes on the pile, but we don't get to hear it. Remember, circumstantial evidence is evidence. That means that juries can hear it and they can say, what are we going to do with it? You started this by talking about how this concept of what he did, which was cut up the body, get rid of the body, made it impossible to try this. Well, guess what? That's also circumstantial. So if you're smart and you think about what a prosecutor can do, and should do, by the way, you argue those issues as circumstantial and say, we would love to have shown you more, but guess what? He chopped her up. And you don't hold back and you stand in front of a jury and you go after them viscerally and say, we want you to go after him because this guy is a cold-blooded murderer who then afterward had no problem with cutting her to bits and make them angry and make them stand up and fight for this. But they didn't bother to do that.
Jack, I've got a follow-up for you. On principle, should prosecutors have wanted to try this just so there's no reward for getting rid of the evidence?
Yes. Yes, 100%, because frankly, if we're going to talk policy now, policy in the bigger sense, which is, well, that tells me if I'm some would-be murderer out there, doesn't that mean the first thing I need to do is roll every body through a wood chipper? Isn't that what I should do next to make sure that nobody gets anything? And we can't be doing that as a society. Remember that the criminal justice system isn't just about this case. It's about what we do for society so everybody buys in. And it also keeps bad people from doing bad stuff. If you do both of those things, it makes the world, it makes society, ideally, better. Isn't that what we're trying to do here?
Oh, and that's where we have to leave it. Thank you all for your opinions. We've got to get to our break. But again, this is a defendant who is now going to be serving 14 years. He was 40 when it happened, so potentially 54 when he is released. Next, we are going to go beyond the gavel, breaking down the biggest true crime cases and trending headlines. We have a defendant who was 16 when he stabbed and killed another teen at a party, facing a second trial on charges after the jury deadlocked last year. What we're going to expect in the second trial and how he was acquitted of the most serious charges the first time. Up next. Welcome back to Court of Opinion. We are taking you now beyond the gavel. Those cases that haven't played out in a court of law with a trial, but investigations that have everyone talking about it while the process plays out. And this one hangs in the balance. There was a trial on this case, all eyes on a young defendant in Connecticut who is soon going to face a retrial on charges that the jury deadlocked on during his first trial. In this case, a house party brawl caught on camera left one teen dead, 3 wounded, and Raul Valley on trial for murder. In the initial trial back in 2025, the jury struggled over Valley's culpability in the stabbing that was sparked by a high school rivalry. The outcome of this was a partial verdict, not guilty of first-degree murder and assault, and a mistrial was declared on other charges, including manslaughter and reckless first-degree assault. Now, at trial, the defendant took the stand. He claimed self-defense and defense of others.
What did you see Tyler Da Silva doing?
He was also on the ground getting beat on.
Why didn't you just get in that car and leave?
I saw my best friend, somebody that loved. Nobody was helping him.
Now, the very latest is that Raul Valley is going to be back in court tomorrow for a hearing that serves as a deadline for him to find a new attorney for this retrial. If he doesn't have an attorney, he will have to apply for a public defender. We also may get a firm trial date there. Also, a new jury is going to be selected after that trial date gets set, and prosecutors are going to be pushing forward again this time to get a manslaughter conviction for Raul Valley. Let's bring in our guest panelists. Here with us, Dwight Williams, Jack Rice, and Eklund Mercy. Jack, let me start with you on this one. This is a case that we all watched play out here on Court TV last year. This jury struggled with coming to a verdict in this case, and ultimately they didn't find, which is allowing us to go forward, the manslaughter, why do you think we didn't have a plea in this case when murder is now completely off the table?
Well, I think we didn't previously because there was nothing on the table for Raul Valley to take. And yet at the same time, he was extraordinary on the stand. He was compelling. He came across as credible. He came across as honest. And I think it really highlighted the weaknesses of the case because remember, you have the right to self-defense and defense of others, which is exactly what he argued. And that's going to work in every charge, including the manslaughter, if the prosecutors think they can bring it this next time around.
Yeah, prosecutors making the decision to do a retrial, Dwight. What's your opinion of this case and what you've seen, and how do you think things are going to move forward for this trial?
Well, first of all, I think this defendant did an outstanding job on the witness stand in the first trial. Self-defense case, I think the jury needed to hear from him, wanted to hear from him, and it worked out for the defense team. He was put on the stand. He withstood a barrage of cross-examination from the prosecutor. And I think the proof is in the pudding in terms of the verdict and more importantly, what they were deadlocked on. This second iteration of this, I don't know what the prosecution's doing here. I mean, you had a good 12 group members of the jury consider the facts, evidence in this case. I think we're going to see a sequel here if this moves forward. I don't think the prosecutor's going to be able to try this any differently than they did before. I think, if anything, the defendant's going to be emboldened, feel more confident on the witness stand if he decides to testify again. So I would lean towards either not trying him again or somehow trying to get him into a plea deal to not go through this process again. It's just my opinion.
Eklund, should there be a plea deal offered by the prosecution? I mean, we don't know for sure.
I think so, absolutely. I think it's the opposite of the case that we just talked about before. We have prosecutors who don't want to prosecute and prosecutors who are prosecution happy. And I think that the issue with the last case is jury selection. I think that when you have parents on the jury and just the possibility of your child or, somebody that can be in that situation and how familiar it can feel. I think that's what it was. I think that you're in a state with many colleges, you're dealing with a young child, like all of that is based on jury selection. I think that that's what the second trial is going to be based on. If you get parents, if you get people that understand how things can just get out of hand, I think that that'll be in his favor. But I do believe that a plea deal should have been done in this case.
When we're thinking about this second trial, it's important to remember the victim's family. They have to go through another trial if that is the case. I want to take a listen to Kevin McGrath. He's the victim's father, the one who was fatally stabbed in this case, where he's talking about his reaction to the initial verdict.
I'm astonished at the result. But, it's due process. He's entitled to it. And at the end of the day, the jury made their verdict. I'm not sure, if they're in the same courtroom as we all were together. But that's the verdict, and we'll live with it, and we'll work closely with the prosecution to get resolution. I was ready for maybe manslaughter. I was not ready for not guilty. I'll be honest with you, I don't think anybody was here.
And Dwight, sometimes rightfully so, the prosecution is thinking about what the family wants. And if they are pushing for this to go again so that the person who killed their child doesn't walk free completely, he's out on bond. But what are your thoughts on that element?
Yeah, I mean, that is very understandable, and I get where the family's coming from. It seems like we've spoken a lot about family and victims this evening. But ultimately, once again, at the end of the day, this is just a sequel to what took place several months ago. What is changed here? What is different? Is there new evidence that the prosecution is presenting? Are they going to try the case differently? And once again, I just don't believe that this defendant is going to do any worse than he did on the witness stand at the previous trial. So sometimes you have to have these hard discussions with victims and with their families and say, hey, let's try to work something out here so you don't have to go through the pain and heartache of a second trial which is likely to lead to a similar resolution, more importantly, no resolution, because the jury's going to be deadlocked again, probably.
And that's what you don't want on either side. The jury foreperson was actually interviewed by Connecticut news station WTNH News 8, and the foreperson said that the jury never even reached the issue of self-defense. They deadlocked over whether his intent was required, whether they could understand the intent, which was a required element of these crimes. He said the jurors concluded that Valley didn't intend to kill McGrath or have the required knowledge to fatally stab him. Quote, he would had to have known which ribs he had to go through and that the knife would go straight into the body. That's what the foreperson said. Eklund, can you react to that? Did the jury understand their assignment? They could make a determination on intent based on the facts. So it sounds like they said there was just no way for them to know.
Yeah, but that's what the jury is. That's the roll of the dice. And the jury once the jury made their decision and they said that they can't even see intent, and it kind of coincides with the testimony, that's that. Now, you can always pursue civil charges. You can always pursue a civil case. But I think it's a dangerous precedent to start saying, hey, I don't like that verdict, let's try again. That's not the prosecution's job.
Eklund Mercy, thank you for those opinions. We have got to get to a break on that one. January 6th tomorrow is when they're going to have a hearing. We'll bring you that here on Court TV. Coming up, hot takes, cold facts, everything you need to know on the trending headlines today. Stay with us.
Tonight on Closing Arguments, the latest in the biggest cases from across the country. We're live bringing you expert insight into all of today's new developments.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
The school shooting that broke hearts around the country and broke trust with law enforcement. Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage this week on Court TV.
Welcome back. Our Court of Opinion experts, they have strong takes on all of the trials we bring you here at Court TV. And now we want to get their hot takes on some of the big legal headlines that we are covering. And because we want to get to all of these cases and hear from everyone, our seasoned panel is going to have 25 seconds on the clock to state their case. Before we get their hot takes, here are the cold hard facts for our first headline. In Phoenix, a newly released police report reveals that a 9-year-old allegedly killed by her father and stepmother reported abuse months before her death. Rebecca Baptiste ran away from home on October 17th of 2024, ended up at a gas station where she told the manager there that her stepmother was abusing her. She was taken to the hospital, and Rebecca told police that her stepmom made her run laps and hit her with a brush and belt. Police concluded the October 2024 incident didn't rise to the level of a criminal prosecution because the young girl provided various iterations of the story, and the stepmother denied causing any harm to her. Now, Richard Baptiste, along with his stepmom, Anika Woods, are facing first-degree murder and child abuse charges. Both have pleaded not guilty in this case. Let's bring in our guest panel, our power panel still with us, Dwight Williams, Jack Rice, and Eklund Mercy. Dwight, I want to start with you. Your take, 25 seconds on this revelation.
Yeah, once again, it's just a sad, sad story where DFACS, Child Protective Services involved. Unfortunate that for some reason they did not activate what they needed to do on the ground to get this child the help that she needed. It is just so tragic and unfortunate that this child had no voice. She tried to voice it, and no one really reacted to her. So, once again, a lot of facts need to come in, but shame on CPS there, shame on Child Protective Services, and let's end this.
Eklund Mercy, your thoughts?
Like, when do cops just take the defendant's word for it? I have never seen that. So the mom said, oh, I didn't do it, and suddenly we just gonna let them go, just let him ride? No. And then the fact is that they should have made a recommendation. The police officers should have made a recommendation for DIFAS, for Child Protective Services. That they dropped the ball and then kicked it.
Yep, that's the time. Eklund, Jack Rice, your take.
How many dead kids? How many dead kids do we need, right? You don't need to have a prosecution to have Child Protective Services in. They can step in long before that, and they should. They're also incredibly underfunded. We have seen this on a nationwide basis. How many dead kids have we counted in the last year? 2, 3, 5. And you ask yourself, how much more should we spend? How much do we got?
Jack Rice, appreciate your comments. Let's move to our second story. This one out of Idaho. More than 3 years after her brother brutally murdered 4 University of Idaho college students, the killer's sister is speaking out. In an interview with the New York Times, his sister Mel says she had no idea he could even be the killer. She said she was angry to see people speculating that her family knew he was the killer and said that she would have turned him in if she knew. She also said the family has remained silent all of this time to respect the victims' families. Eklund Mercy, let me start with you on the decision to do an interview like this. Was it necessary? 25 seconds.
I guess. First of all, were they twins? Because that is uncanny. Then second of all, I think that Kohlberger may have had something up his sleeve. I don't think that case is done by a long shot. I think that we're going to find a lot of surprises coming up. That case is not done by a long shot. We're going to keep hearing about it.
And Jack Rice, let me get your take on this interview.
There's a lot of victims in cases like these, and sometimes people don't realize it's the victims of the perp themselves. It's the victims of the defendant themselves, because they have to live in the wash of somebody who kills people. And the problem is they're trying to understand this too. And how do you look at your child, the one that you birthed, the one that you raised, and you said, I created a monster. Was it my fault? That's a Vic too.
Dwight, final take on this one. She said that she saw him in that time where he was essentially a wanted man.
Well, first thing that she should have done was apologize to the victims and their family. She had an opportunity. If she's going to go into public realm now, she had the opportunity to do that, and she failed to do so. I hope she rethinks that. Second of all, she certainly has the right to speak out about her brother, but ultimately, once again, in terms of the timing, in terms of how the victims' families take it, I think that timing was a little bit closer to when this plea deal or this sentencing took place as related to Kohlberger. So it's a little too late as far as I'm concerned.
They did say that they stepped away from the plea deal because they wanted to respect the family. Let's move to our third and final story of the night. Tyler Perry has been sued again for sexual assault by an actor who was in one of his shows. And that actor is now seeking $77 million in damages. This is the second lawsuit in recent months accusing the studio mogul of leveraging his power in Hollywood to make sexual advances. Mario Rodriguez alleges that Perry subjected him to repeated unwanted advances over several years, including sexual battery and assault inside of the mogul's home. Now, Rodriguez has also sued Lionsgate, which distributed the 2016 film Boo a Medea Halloween is the name of that one. The alleged victim was in this accused the studio mogul of turning a blind eye to Perry's alleged misconduct. Now, Perry, through his lawyer, has denied all of these allegations. Dwight, what do you make of this one? What's your take on it? This is a second lawsuit. He's a very powerful person. 25 seconds.
Yeah, in this Me Too era that we're still in, there's a little bit of smoke, there's fire here, perhaps. Certainly, I'm curious to see what this victim has to say once it reaches to the trial level, or certainly some sort of press conference. At the end of the day, I'm very, this is not the old Hollywood anymore. This is the new Hollywood, and victims matter, their voices matter. There should be some accountability, some protection by the studio as well, which is interesting that they drug them into this lawsuit. So,
Jack Rice, your thoughts on this one?
You never know how this is going to play, but Tyler's got deep pockets too. And there's a lot of motivation that's out there. You never know if it's real. You never know if it's fake. We've seen it before. Hopefully we're going to get some real answers so everybody can clear this up.
All right, Eklund Mercy, I want to quickly get yours.
Quick?
That is really quick. Eklund Mercy, last take, as quick as you can.
He's a billionaire, so he can't afford to just settle. And I think that if he followed all of the directions, like did they report it to H&R? Did they report it to H&R? Did they do that? That will dictate how far this
Mercy, we are out of time. Thank you for your comments. Thank you for connecting with us this hour. I'm Julia Janae. And remember, respect the other person's opinion. We can all have opinions.